One thing I'm very surprised about, and I guess I underestimated it before we started interacting, is the pushback that you receive from inside the judiciary against this sort of trying to make it more fair, trying to argue, for instance, for more data and more statistics, a little bit more transparency. That's something I was very surprised when you brought it to my attention. Where does this pushback come from, in your opinion? If we're trying to steelman it a little bit, what kind of concerns is it trying to? Is it just that people, human nature, people enjoy not having that level of scrutiny? A combination of bureaucratic inertia and human nature is my sort of hunch. But where do you think it comes from? And can you please talk about that a little bit?
Yeah, I found in the justice system, change is very difficult. It's very difficult to convince the powers that be that we need to move in a different direction. I found that as a young prosecutor. We used it in the state of Ohio. We did not have open discovery in the state, and therefore I did not have to disclose to the lawyer for the accused copies of police reports, witness statements. So they would actually come to pretrials, and I would read them the information that was in my file. They would take copious notes, and they would have to trust that I was telling them everything that they needed to adequately represent their client. And it was crazy. People were when I became a judge early in 2005, it was not uncommon in every trial for someone to claim, I am getting new information that was not provided to me until last night or, mid-trial. And we'd have to send the jury out of the room. And finally, the defense bar in the state stood up and said, this is crazy. And we changed the rules. And there was a lot of pushback, and there was a lot of fear that victims would be victimized. And we passed a rule and it advanced the system, and those claims about being ambushed at trial, virtually disappeared. And that taught me a big lesson. And now I see the same fears being expressed about data. And, data is simply relevant information that can better inform your decision making. I use this analogy that perhaps your listeners have seen the movie Moneyball. And it's a great analogy because it focuses on baseball and who the decision makers were, and when it came terms to hiring which players they were going to hire. And they used to rely most heavily on the scouts, who had a lot of institutional knowledge, and they would act on hunches, and sometimes they were right, and sometimes they were really wrong.
Also egos and reputations.
Right. And using your gut, quite frankly. And, it's when they went to a more data-driven evaluation, they changed the game of baseball altogether. And so that's an example of how powerful data is. It also is an example of how our society is moving in general. And what I say to judges who are wary of this, look, the genie's out of the bottle. This is coming whether you like it or not. Your decisions on sentencing are going to be scrutinized at a level that you never, ever anticipated. So if you want to be able to defend yourself against possibly unfair characterizations of data analysis, you best get on board the data train and have the data yourself, so that you can defend against these claims. You can put your record in context, and judges are coming around to that fact. The fear kind of reminds me of, remember a couple of years back when the music industry changed because people could all of a sudden record thousands of. You didn't have to buy CDs anymore; you could record. Everybody was like, "This is terrible! They're stealing our let's prosecute all these college students who have all this music on their files." And then they finally came around to the world has changed. And the company and the music company said, we're going to find a way to monetize this, and we're going to act accordingly.
ultimately led to a growth of the music industry and an increase in revenues for them down the line. It was a difficult moment to kind of switch the business model, but ultimately it ended up being a good thing, although maybe not for the artist. But this is very interesting, and so I love it that how much you're talking about this with other judges, and I've thought about this a lot. I'm involved in a venture, a legal AI venture, where essentially exactly like you say, decisions are public up to a certain point, right? Where there's a lot of settlement discussions and settlements that are not public, but to the extent that we have access to a lot of high quality public information in the legal system, which is supposed to be, what the legal system is about, transparency, disclosure, treating like cases of similarly, that's sort of the heart of the legal system in a democracy that respects the rule of law and so forth. But in thinking of the role of AI in this, I'm kind of coming to a very similar realization that you are, is that I believe the best version of this is one where we have the data and the statistics are informing us about the potential biases that exist in a particular case and informs the judge. And then I believe that the judges, now people might say, well, if you tell the judges, then they'll just hide their bias. Great. I would rather they hide their bias, right, than express their bias. Or maybe if you just make them aware. I believe most judges are extremely hardworking. They're for the right reasons. They don't want to contribute to any kind of injustice. Some of them perhaps are extremely ideological, but in my experience, that's the minority. Judges tend to be quite conservative intellectually. They want to make the right decision. They're exposed to all kinds of bureaucratic forces, all kinds of constraints in their sort of their work modalities. If you gave them access to better information, better statistics, okay, in this kind of case, in your state, in the last 5 years, these are the trends. This is the statistic. Now, you take that into consideration in making your decision, but you're still going to be making your decision. But ultimately, you can sort of self-scrutinize, right? And eventually, if it goes on appeal, the appellate judges can also take a look at the statistics and say, well, you're playing into one of the biases. Now, it doesn't mean your decision was wrong, but maybe I'm going to take a little bit of a closer look here. Is this not an example of a sort of an unexpressed bias or one of these trends that we're seeing? I just see it as additional information for judges. That's I think the best way that we can use the system if and when it emerges.
I could not agree more. Built into the cornerstone of our current sentencing scheme here in Ohio is the tenet of justice that we all know about, that you should treat similarly situated defendants with similar sentences, regardless of the color of their skin or their socioeconomic place in society. And I always had that laminated on my desk. And when I was sentencing people every single day, I didn't have any tools or information. I just had to simply try to do my best. And there's a great anecdote that came from an attorney, a criminal defense attorney I know from Columbus, and her name's Diane Menashe, and she's a very good defense attorney, and she was representing a defendant who was charged with involuntary manslaughter. She was a heroin addict, and she had supplied another heroin addict with unfortunately, tragically, a lethal dose of heroin. And so the prosecutor and Diane could not come to any type of agreement with regards to sentence, but they were before a judge that they believed was very fair and would listen to both sides. So they pled the case out, and in Ohio, judges can have tremendous ranges available to them at any given plea. It could range from probation to, like you said at the beginning, decades in prison. And they just thought they would take their chances. Diane, fortunately for her client, heard through word of mouth that the state was going to ask for 13 years. And she intuitively knew that was way out of range from other cases she had represented that she was aware of. She invested about 50 hours of time combing through the county public records to get similarly situated cases to put together a sentencing memorandum. It took her hours and hours that no defense attorney usually has. And she put together the sentencing memorandum. And sure enough, at the sentencing hearing, which you could imagine was very emotional, the state was demanding 13 years imprisonment. And Diane very calmly said, "Judge, I'd like to remind you of your duty under the law to treat similarly situated defendants with similar sentences. Here are the cases, some of which are your cases, Judge, some of that you sentenced, and they're virtually indistinguishable on paper from the case at hand. And the judge, like you just said, judges want to be fair. And if you're going to treat someone differently, you better be able to articulate a good reason why. And if you can't, then that's the power of data. And Diane was able to get the sentence way within the range that other people had been treated. And that's just a perfect example. It points to the solution. It also points to the problem that we don't have access, at least here in Ohio in the state courts, to that kind of data. The federal system is far above us in terms of the amount of data that they have.